The early months of 2025 have been marked by significant shifts in United States immigration policy. President Donald Trump, upon beginning his second term, swiftly moved to implement a series of measures reflecting a more restrictive stance. Central to these changes is Executive Order 14161. This order, signed with little prior public discussion, has immediately sent ripples across the globe. It specifically targets a number of Asian countries, signaling a renewed focus on controlling entry into the U.S. from this particular region. The implications of this directive are far-reaching, affecting not only individuals but also international relations and the very fabric of America's image as a nation of immigrants. Families with members seeking to immigrate, students planning to study in American universities, and businesses relying on talent from these regions are now facing an unpredictable landscape. The timing of this order, early in the new administration, underscores its priority. Observers are closely watching how the Department of Homeland Security and the State Department will interpret and enforce the new rules. For travelers and aspiring immigrants from the targeted nations, the immediate future is fraught with difficulty. Executive Order 14161 does not apply a uniform set of restrictions across all targeted Asian countries. Instead, it employs a tiered approach, ranging from comprehensive travel bans to less severe, yet still impactful measures. Some nations, such as Afghanistan and Cambodia, according to initial reports, face what appear to be full bans on entry for their citizens. For other countries on the list, the order imposes partial restrictions. These might include limitations on certain visa categories, increased scrutiny for applicants, or quotas on the number of individuals allowed entry. In addition to outright bans and partial restrictions, Executive Order 14161 also includes provisions for issuing diplomatic warnings to certain Asian nations. Such warnings can strain diplomatic ties and create an environment of unease for citizens of those nations, even if direct travel restrictions are not immediately imposed. Legal experts are already dissecting the language to identify potential grounds for challenges and to advise affected individuals. The implementation of Executive Order 14161 is projected to directly impact millions of individuals across the targeted Asian countries. These are not just abstract numbers. They represent people with dreams, families, and careers intertwined with the possibility of entering the United States. Students who have spent years preparing for an American education now find their ambitions in jeopardy. Families separated by oceans, hoping for reunification, face indefinite delays or outright denial. Skilled workers who were recruited by U.S. companies may see their opportunities vanish, impacting both their personal lives and the businesses that sought their expertise. Consider the plight of those from countries like Afghanistan, a nation already grappling with immense challenges. For many Afghans who worked alongside U.S. forces or international organizations, the promise of resettlement in America was a lifeline. Similarly, in countries like Cambodia, individuals seeking educational opportunities or family connections in the U.S. now confront formidable obstacles. The economic consequences are also significant. Many Asian countries rely on remittances sent home by citizens working in the United States. The human cost of Executive Order 14161 extends beyond individual hardship to encompass a potential erosion of trust and a weakening of the people-to-people ties that underpin international relations. The Trump administration has indefinitely halted the U.S. Refugee Admissions Program, or USARAP. This suspension, effective from January 27, 2025, closes America's doors to most refugees. Thousands of vetted refugees now find themselves stranded, their hopes for safety put on hold. International agencies have condemned this move, warning of a global crisis. The long-term consequences on global stability and human suffering could be substantial. Beyond the ban, a sweeping crackdown on immigration. The early days of the second term have seen a much broader and more aggressive crackdown on various fronts. This includes a concerted effort towards mass deportations of undocumented immigrants already within the country. Reports indicate a significant increase in arrests by Immigration and Customs Enforcement, or ICE, often resurrecting policies and tactics from the president's first term. One particularly controversial move has been the invocation of the Alien Enemies Act of 1798. This archaic law is being used to attempt the deportation of Venezuelan migrants to a third country location, specifically a prison in El Salvador. The use of such an old and rarely invoked statute highlights the administration's determination to find new legal avenues to expedite removals and bypass existing immigration court backlogs. Redefining American identity. Challenges to birthright citizenship and visa security. The administration's immigration agenda extends to fundamental questions of American identity, most notably with a new executive order aiming to limit birthright citizenship. This order proposes that children born in the United States would only automatically acquire citizenship if at least one parent is a legal permanent resident or a U.S. citizen. This represents a radical departure from the long-standing interpretation of the 14th Amendment. This move to redefine birthright citizenship has, predictably, triggered a wave of legal opposition. Beyond birthright citizenship, the administration is also tightening screws on visa holders already in the country. In a controversial move, hundreds of students, primarily from Middle Eastern backgrounds, had their visas terminated under a provision citing adverse foreign policy consequences. These policies, targeting both the definition of who becomes a citizen and the security of those legally present on visas, contribute to an atmosphere of uncertainty and anxiety. Systemic overhaul, legislative actions, and heightened scrutiny. The Trump administration's efforts to reshape immigration policy are not confined to executive orders. They also involve legislative maneuvers and systemic changes to visa processing. A significant budget reconciliation bill, recently passed by the House of Representatives, exemplifies this approach. If enacted by the Senate, this bill could lead to over 10 million people losing health care coverage and could strip 4.5 million children in mixed-status families of their eligibility for the child tax credit. The same budget bill significantly increases funding for immigration enforcement. It allocates an additional $45 billion for immigrant detention and $14 billion for deportation operations. Another key systemic change is the implementation of enhanced vetting for all visa applicants, mandated by a separate executive order. This enhanced vetting process, while ostensibly aimed at improving national security, can create significant barriers for legitimate travelers, students, and skilled workers. Echoes of the past historical parallels in U.S. immigration policy. The current wave of restrictive immigration policies under the Trump administration, while seemingly novel in its breadth and intensity, finds numerous parallels throughout American history. The United States has a long and often troubled relationship with immigration, marked by periods of openness interspersed with episodes of intense nativism and exclusion. The invocation of the Alien Enemies Act of 1798, for instance, draws from one of the earliest pieces of legislation granting the president power over non-citizens during times of perceived national threat. The late 19th and early 20th centuries saw a surge in discriminatory immigration laws. The Chinese Exclusion Act of 1882 stands as a stark example, effectively barring an entire ethnic group from immigrating to the U.S. for decades. The current focus on specific Asian countries in Executive Order 14161 inevitably evokes memories of these earlier exclusionary eras. The Immigration and Nationality Act of 1952 continued national origins quotas, though it also codified and organized existing immigration law. Understanding this historical context is crucial. It reveals that the current debates over immigration are not new, but are part of an ongoing struggle to define America's identity, its borders, and its relationship with the rest of the world. The road ahead: legal challenges, public opinion, and diplomatic fallout. The array of new immigration policies introduced in early 2025 is already facing a barrage of legal challenges. As seen with the Birthright Citizenship Order and the attempted use of the Alien Enemies Act, civil liberties organizations, state attorneys general, and affected individuals are quickly turning to the courts to block or overturn these measures. These legal battles are likely to be protracted, navigating through district courts, appellate courts, and potentially reaching the Supreme Court. Public opinion on these aggressive immigration measures appears to be divided, though concern is growing. A recent CNN poll indicated that 52% of Americans believe President Trump has gone too far in deporting undocumented immigrants. The diplomatic fallout from these policies, particularly Executive Order 14161 targeting Asian countries and the suspension of the refugee program, is substantial. Allies and adversaries alike are watching closely. Targeted nations may retaliate with their own measures or reconsider cooperation with the U.S. on other fronts. The coming months and years will reveal the lasting consequences of this pivotal moment in U.S. immigration history, a history that continues to be written